Okay, let's go ahead and get this very fun party started. Welcome everyone to TBA CLE, Discovery Practices and Employment Law. We are lucky to have with us this morning an illustrious panel of judges that is going to discuss this with us. Our conversation today is going to be moderated by Heather Collins. And I did want to give one quick housekeeping note before I leave the chat. You will be able to certify this course in your TBA CLE account. So give us a few moments after the program ends, and you will be able to certify with abandon, if you will. But I am going to go ahead and leave y'all to it. Heather, thank you so much for joining us, and judges, thank you for being with us this morning as well. So Heather, take it away.
Thank you very much, Brooke. This morning, we have a great panel of magistrate judges from all three divisions of the federal courts here in Tennessee. We have Magistrate Judge Barbara Holmes from the Middle District of Tennessee, Magistrate Judge Charmaine Claxton from the Western District of Tennessee, and Magistrate Judge Cynthia Wyrick from the Eastern District of Tennessee. And we're going to discuss it seems like I've heard from several judges that discovery disputes are unfortunately at an all-time high. They've seen more discovery disputes. I'm sure as attorneys, we've all experienced more discovery disputes, particularly since the COVID era. I don't know if being stuck in our homes affected our ability to work things out, but it seems to have done that. And so this morning, we're going to ask the judges and just pick their brains, how we can head off these disputes, how we can behave better, and get recommendations about when it is a good time to go to the magistrate judges for your disputes and how we can try to work things out in a more collegial manner. So I'm going to kick things off with Magistrate Judge Holmes from the Middle District. And Judge Holmes, the initial question is about Rule 26F conferences, or the proposed case management order. And in particular, how can we better utilize that procedure and make it more effective to contemplate discovery issues down the road? I know that you've built on your case management order as you've been on the bench. And so I'm sure that you have feelings and thoughts about this. And we'd love to hear from you about how we can utilize this procedural tool to avoid, hopefully, more discovery issues down the road.
Thanks, Heather, and thanks for inviting me and my colleagues to participate today. We're happy to share some thoughts with you about this topic. I think the Rule 26F conference, which we require a little bit differently in the Middle District of Tennessee, it's not a specific requirement. It's in the context here of preparation of a proposed initial case management order, but encourage you to have all of the same kinds of discussions required by Rule 26F. And it can be a really effective tool for early identification of potential discovery issues, even before you're making your initial disclosures and sending out formal discovery. It is an opportunity to be talking about what are the potential discovery issues. You all know the case, even though it's the early days. I suspect that many of you who are representing parties by the time it gets to federal court are already well familiar with the underlying dispute. And so if not even in this particular case, certainly in similar kinds of cases. So you can talk about, is there going to be a really large scope of discovery? For instance, does the defendant anticipate that there's going to be voluminous documents to produce? You know what you're going to be asked for, and you should be having a conversation with your client and then with opposing counsel early about the scope of discovery. Is most of the discovery electronically stored? So you need to talk early about electronic discovery protocols and procedures. How are you going to manage ESI in the context of the case? We also really utilize initial disclosures here under 26A1 as an opportunity to further those discussions, because I require that the parties exchange copies of responsive documents and materials, not just descriptions of those documents or materials. And that's for a couple of reasons. The first of which is it can be very helpful to also identifying issues early. Plaintiffs' lawyers know what they expect to see if they receive initial disclosures, copies of documents that they think are much fewer than what they anticipated, then that can be a time for them to reach out and have that conversation about, are there other documents that should have been disclosed? Here's what we're going to be requesting in written interrogatories and requests for production. There can be, and if all of those documents that you have to disclose copies of or exchange copies of or ESI, at least identify what those documents are going to be. But my standard requirement is that you exchange copies of responsive documents and not just descriptions. That also helps refine the discovery, I think, because then once you've gotten those exchange of copies, then you know that those are not documents that you need to later request. So I think it can be a very helpful opportunity. Let me also talk about just what the next step is then, at least in the Middle District of Tennessee, and what Heather was talking about in terms of refining my procedures. And the first of those is that I require that in resolution of any discovery disputes. So now we've sort of gone from what can you do early to we're now more in the middle of discovery, and what are you going to do when there's an actual dispute arise? I have a requirement, and I think it's pretty standard across this district at least, that lead counsel must meet in person. So when Heather was talking about stuck in homes, that sort of resonated with me, because we did modify that requirement to at least have a video conference during the time that we were all quarantined at home. But it is an in-person meeting among lead counsel, with the expectation that if that most senior lawyer on the case, who is probably also the client contact, has to get involved by meeting in person at some point, then they're that much more inclined to either give directions to the more junior attorney to work out the dispute or to work out the dispute themselves. And that in-person meeting is just what it sounds like. You actually have to be in the same room at the same time talking about the specific issue or issues in dispute. So if you're located in two different cities, that means that you're going to have to decide where you're going to meet. I have, as part of the discovery resolution process, ordered lawyers to meet at different places. Judge Claxton will appreciate this. I ordered the lawyers to meet at the grocery store in Bucksnort in one case, because one was in Jackson, one was here in Tennessee and here in Nashville, and they couldn't decide, even that was the level of disagreement, that they couldn't even decide where they were going to meet in person. So I ordered them to meet at the grocery store that is famous for its fried bologna sandwiches in Bucksnort. And we have found, at least anecdotally, that there are fewer discovery disputes. You don't have to start your attempts at resolution of the dispute by meeting in person. You can exchange emails. You can and should pick up the phone and talk to each other. But at some point, before you can bring it to my attention, you do have to have that in-person meeting and certify that you did hold that meeting in person. And I think that talking to each other is important. That's another frustrating thing that I see, is this exchange. Before I instituted this in-person requirement, but even as part of the current resolution, I see this whole predicate of exchanges of emails where they're not really talking directly about the issue. There's a lot of posturing and that kind of thing. And that's a good reason why you need to meet in person. Before I instituted this procedure, I'd have a discovery conference call and ask the lawyers to tell me what the issue was, and someone would describe the issue and the other lawyer would say, oh, well, I didn't know that's what you wanted. That's fine. So the talking to each other is really important. And I also have very limited scope of what you can file in connection with a discovery dispute. I don't allow the filing of a motion to compel or a motion protective order as a matter of routine or as a matter of first filing. You file a joint discovery dispute statement. It's limited to 3 pages per party per issue. And you have to describe your issue in those 3 pages, include your factual support and your legal authority. You better use that 3 pages wisely and well, or however many the issues are, the allowed pages, because I may not allow the filing of a separate motion to compel or motion for protective order. I generally don't. because most discovery disputes, except in the most complex of cases, don't warrant the 25 pages of each side briefing that our local rules would otherwise allow. And it's just full of extraneous arguments about why clients win on the underlying merits, or full of hyperbole about one side's opinion of the other. So not very helpful. So I think those procedures have really streamlined at least the discovery disputes that are appearing, that wind up in front of me, the cases, the lawyers who appear in front of me. I would also just sort of, as closing, add one more suggestion to you, that a lawyer who, very well respected senior lawyer when I was a young lawyer, gave me this bit of advice, that every year you should fire your worst client. That will not only improve your stress level, but also improve the quality of your practice and probably your reputation in the court, because client management, I think, is often a big part of discovery disputes, that one lawyer or the other is not really being candid with their client about what the judge's expectations are going to be and what the likely outcomes are. And that poor client management then translates into unnecessary and wasteful discovery disputes. So good client management, talk early, talk in person, and you should be able to resolve a lot of discovery disputes if you're doing all of those things. That was a little bit off topic, Heather, but I hope it was helpful.
No, that was super helpful. I think that the sentiment of that emails can get out of hand is one that we can all relate to, one that probably every attorney that's listening on this Zoom, including myself, has been guilty of, where it just ratchets up and up and up, and a snarky email goes out and then a snarky one comes back. And but I'm all about the resolution, about solving things over a bologna sandwich, a fried bologna sandwich. I mean, if there's anything more Southern than that, I don't know what it is. But
well, you know, Judge Higgins, who for years was a valued member of this court, his standard comment was, the problem with lawyers today is they just don't drink enough whiskey together. So fried bologna sandwich, a whiskey, whatever it is that's going to break the ice a little and break the discovery logjam, I'm all for and strongly encourage.
Well, yes, and I have a colleague on the other side of the bar, and he would always propose a beer summit. And I knew if he was calling a beer summit that he either wanted to just talk to me about like where our clients were in a more authentic way and how we could get the case resolved, or try to assist with a log jam. And that goes back to your point that sometimes the clients have these unrealistic expectations of us, and then that puts us in difficult positions that, we're arguing over things that we really shouldn't be arguing over. So I really appreciate that aspect of it. And going back to your statement about the providing documents at the proposed case management, or discussing those at the proposed case management order and listing those out. Since this is the employment labor section hosting this webinar, can you expand on some of this particular documents? I mean, we see a lot of the same documents in labor and employment cases, personnel files, medical records if it's an ADA case, emails between HR and supervisors. Can you expand a little bit on some of the things that you've run across when you're laying out those specific documents that the parties should be exchanging at the initial disclosure stage?
Well, and I in most of my cases don't specifically spell those out, because you all, again, know the case better than I do, and you know what you're expecting to see and what you're likely to produce. But there have been employment cases in particular where I have a very detailed list of kinds of disclosures that need to be made. It's really based on, and I think it was actually Chief Judge Crenshaw who maybe suggested that this be included. And it's based on some pilot districts where there were early discovery requirements put in place. And it's all the things that you've just described. payroll records if it's an FLSA kind of issue or employment kind of issue, personnel file, complaints made if it's an employment discrimination, and responses, employee handbook, a copy of pertinent sections of the employee handbook, if there's intended to be, and in most cases likely is, a defense that whatever action was taken was consistent with employment practices, or any other kind of communication with the plaintiff at the time of employment or after about the company's policies and procedures regarding employment. And then all the things that you've described, damages kinds of documents, if there's been, if the person is employed elsewhere, then information about new employment. So it's all the kinds of things that you all would expect to eventually see. It's more, the intention of it is to have those exchanged earlier, and then not require such costly discovery, because you can exchange those early on and not have to go through the more formal written discovery. And then also again, what I said earlier, refine discovery, so that once you've exchanged those, everybody has that much more narrow universe of additional things that they need to ask for or want to ask for. And I'm happy to put those in the case management order. I'm happy for you all to specifically describe them. And that probably makes the most sense, is for you all to agree in the case management order what kinds of specific responsive materials or documents are going to be exchanged as part of the Rule 26A1 disclosures. And I am very unlikely to modify that in any great detail if those are the if that is the documentation that you've agreed to. And it can be very helpful to specifically describe it. In a lot of cases, I just generally say that the initial disclosures must include copies of responsive documents, but I'm also happy to provide as much detail or require as much detail in the order as you all either request or propose.
Okay, that's helpful. And you mentioned the early discovery protocols, and this really goes out to all three of you. Have y'all used those much, or Judge Holmes, have you just used that based on a template from Judge Crenshaw, or
well, and
what
I
do y'all
actually
think about
it's a
those?
template that we got from some other court in the Sixth Circuit, maybe, but
Mhm.
I've used it mostly in employment and employment discrimination cases, FLSA and employment discrimination cases, because it was because those are a fairly defined universe of kinds of documents. But I would use it I would use a similar kind, as I said, a similar kind of specific requirements in any other case where there's going to be a pretty easily definable and describable set of documents. Sometimes it's not as easy early in the case to define or describe what the anticipated documents are going to be. Some kinds of cases, it's very easy to do that. So, and just, although it's not this group of people, but another example is car wreck cases. I very often describe that you must exchange copies of responsive documents and materials, including any accident reconstruction, personal or personally obtained, or law enforcement reports, those kinds of things. So sometimes in some cases it's easier to describe what's going to be at least somewhat included, some of what's going to be included in the initial disclosures. Some cases it's not as easy, and I leave it more general, saying copies of all responsive documents or materials.
Okay. Judge Wildrick or Judge Claxton, do y'all have any specific procedures y'all use early on in the cases, or expectations that would be helpful for us to know about?
I wouldn't say that I have anything as specific as what Judge Holmes has, but it does call to my mind something that I think for me when I was a lawyer, and I think for all of you practicing law, you probably run into the same thing. The practice of law is so busy that one of the most challenging things for me was to actually carve out time just to sit and think about my case. And, you know, envision it from start to potentially that jury trial if you have to have it. And one of the things I would really encourage people to do is make sure you set aside that time early on, even when it's the type of case that you handle all the time. Go back and hit the books, go back to the basics. What do I have to prove if I'm the plaintiff to make my case, to make out my claims? And in doing that, what discovery do I have to make out each essential element? If I'm defending, what documents do I need to knock out some of these elements that plaintiff will be trying to prove? But by doing that, I think you really help yourself be prepared to tell the court, this is why I need this particular discovery that the other side doesn't want to supply. And this is how I have tried to narrow what I need. If it's ESI, this is how I've thought about the cost of what production's going to entail. But, court, I really need X because it's essential to proving my claim, or on the other side to proving my defense. So I do think just some of that good old get back to the basics goes so far. It's just really tough to carve out that time. So again, recognizing how busy lawyers are, I would still just really encourage that early, careful thought about your cases.
That is a great tip, because I think it definitely is labor employment attorneys. We get in going through the motions, and we forget to do that because we start going through those motions pretty quick. Judge Claxton, what about you?
Sure. Good morning, everyone. So in our district, on cases where there's counsel on both sides, the district judges conduct the scheduling conferences, case management conferences. And so really, as a magistrate judge, I don't get into what's being requested on the front end, although I'm taking eager notes on what Judge Holmes has described, because I think I'm going to look at the Middle District's local rules and look at what Judge Holmes has and see if we can't implement some of that here to certainly help streamline and hopefully eliminate some of the problems that we catch down the line.
Okay, thank you, Judge. Well, I'm going to switch topics a little bit, and Judge Wyrick, we're going to kick off with you on this one. And this one's more about the motion practice that comes around. Most of us, and I'm again speaking for a lot of us in the labor employment section here, just because those are my people and the ones I run across all the time, is that we hate to really engage in discovery disputes to the point where it becomes motion practice, or the point where we have to bring it to the magistrate judge's desk. And so in doing so, and whether it's a product of that busyness that you were talking about earlier, or us just going back and forth, hopefully not by emails, but it can sometimes be at the end of the discovery deadlines when we're like, okay, we got to take this to the magistrate judge because we haven't gotten this, and then it can impact deadlines. What are your suggestions as things that you could advise us, and under what circumstances should we get you involved, and when?
Well, I appreciate the opportunity to address that. And, one of the things I'm enjoying about our conversation this morning already is not only hopefully are the lawyers picking up tips, but I love hearing from my fellow magistrate judges across the state, because I think we are able to learn from each other in this forum as well. So this is fun. One thing I want to say first, just about the idea of civility and why it's so important, and why civility in the discovery arena is particularly important, is not only, as we all know, is the practice of law difficult enough, it's challenging, it's busy, there are never enough hours in the day, but it's challenging enough just to get the work done. But when you add incivility to it, and dealing with unreasonable opposing counsel, particularly demanding opposing counsel in a way that's not necessary for the case, it increases lawyer stress and the difficulty in practicing in a way that doesn't need to happen. But the other thing that I want to throw out for everybody to consider as well is the fact that what you're sending out, if it's going to your clients, you know, what does that cause them to think about the case and the process of getting their case to trial? Does it leave them feeling like the process is unfair, that there's not a just process, or that the outcome will be unjust? So when these discovery disputes get geared up and you're sending communication back and forth, especially what you'll be forwarding to your clients, try to think about what impact that may have, because I think, frankly, our justice system has really taken it on the chin lately, in the media and just in general in terms of public perception. So with that, though, to drill down to some practical tips, first of all, I agree with Judge Holmes completely. I want to see really good faith effort to resolve a dispute before it hits my desk. I might be just a little more flexible if you're talking about counsel in California and counsel in Atlanta. I might let them confer by Zoom instead of meeting in person, although I'm not sure Judge Holmes doesn't have the right side of that to require that in-person meeting. But once you have really given it the old college try, then bring your dispute to the court sooner rather than later. Don't let it sit out there and fester and get bigger and bigger over time. I do require, as does Judge Holmes, that you reach out to my chambers if you have a dispute. Usually what we'll do from there is each side will send something by email that very briefly describes the dispute. We'll get on the phone together and try to resolve it in that fashion. If that doesn't work, we'll do Zoom or Teams. And then as a last resort, I may permit some motion practice here. I do not generally like to see emails back and forth between counsel, because to me, email was designed to be an informal communication between counsel where you don't have to worry about exactly how you said something and the court analyzing that. With that said, counsel, I see emails all the time, unfortunately, in discovery disputes. So when you do send your emails, I think I have to caution you to say, don't put anything in there you don't want the judge to see, because the judge may very well see it. When you're dealing with particularly difficult counsel, at least this was my practice when I was in practice, and I think as a judge, what I prefer to see, the more difficult your opposing counsel, the more formal I would get in my communication. So if you're having real difficulty in trying to resolve a discovery dispute, put in a letter very specifically what you feel like you haven't gotten, what you need, why you need it. And what you're going to be tempted to do is you're going to be tempted to add those personal barbs in there about how unreasonable your opposing counsel has been to get you to the point of writing this formal letter. But I will tell you, the court will so appreciate it if you leave it out and just address those points of what you need. Because, you know, all of the judges you have before you have sat where you sit now at one time. We all get it. We know there are difficult opposing counsel out there. So it's not something where, you know, we think it was just all wine and roses to get to the point that a discovery dispute has landed on our desk. And I'll say this too, at some point, if you don't resolve it, you're going to be talking to us either by telephone or you're going to be in person with us. And you're going to hear opposing counsel start to get personal, perhaps, in addressing the discovery dispute. My advice to you would be to say, Your Honor, I have a response I can give as to some of the personal matters, the issues that have been raised, but I'm happy just to focus on these issues that we have with discovery. But if you have any questions for me about the process that has led us here, I'm glad to answer those. For me, that will signal to me that there have been lots of problems, that you've got what you think is a very valid response to the personal attacks, but will allow us just to really drill down to what's going on. I think that's probably a good first stab at that. Heather, do you have some other questions or clarifications that I could help with?
Well, so far it sounds like I'm hearing a common thread from all three of you, and that's emails can be our own worst enemy when it comes to discovery disputes, because it's much easier to have one of those off the cuff snarky responses, and then it devolves into a personal attack rather than focusing on the issues. But if we can all heed the advice that from Michelle Obama, that it's better to take the high road. It sounds like, even though in reality that is pretty hard to do sometimes, but we got to just keep coming back to that foundational point. Going back to one of the things that we were talking about with respect to the disputes is that it seems like a lot of times it's because the parties are just going back and forth about objections. Do you have any kind of position about that? We'll start off giving grace and say, sure, have extension. I understand. You need some more time to get things together. And then you get back those discovery responses and it's just nothing but objections. And then things go downhill really quick from that point.
I do have some thoughts on that. And one thing I'll say too, in sharing the thoughts that I am, and I dare say the same may hold true for Judge Holmes and Judge Claxton, a lot of what I have to say, I could be speaking to my former private practice self when I'm giving some of this advice. So I wish I had been perfect in all these respects when I was practicing myself, but sometimes I'm giving these tips because I think, boy, I wish I'd thought more about this when I was practicing. So we all acknowledge it can be very, very difficult. But as to objections, and I was probably as guilty of this as anybody else in practice, it's easy, when you propound discovery, you've got 3 pages of definitions and what, you're supposed to apply to these questions that you're asking and these documents you're requesting. And then when you respond, everything's, objection, overly broad, unduly burdensome, but still blah, blah, blah. Well, as you can imagine, when the court sees that, it is easy for the true objections to get lost in the shuffle. For me, if you bring to me a set of discovery responses you've provided where it looks like you have provided very full information, you've tried really hard to be responsive, but there are a couple of objections you've made that are narrow, they're well thought out, and especially if you have some legal support in there, I'm going to pay a lot of attention to that. So to me, where the temptation is, well, gosh, if I miss something, if I don't throw something in at a definition, maybe the other side can wiggle out of providing what I asked for, or maybe I don't have to provide something. I think you really can lose an important objection, just, forest and trees kind of thing. So make those objections sparingly. And when you do, be ready to really support them with the law. And I think you can make a lot of headway when you have a valid objection.
Yeah, if a party does not, if they just have the boilerplate, I ignore boilerplate. I mean, because it's meaningless. It is absolutely meaningless. I mean, the rules of the comments tell us that we're not supposed to just throw in overly broad and unduly burdensome unless it's supported. And so if you just throw it in there and there is no support for it, so if you're going to say overly broad, explain why it's overly broad. Don't just say overly broad, because that's meaningless. It's wasted ink, and I'm going to absolutely ignore it. And in fact, you know, if it comes to a motion hearing, oh well, Your Honor, well it's overly broad because da 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 da. Well, you didn't say that, so I don't want to hear it now because you didn't raise it in the initial objection. You didn't raise it. You know, you might have raised it in your response to the motion to compel, but why didn't you say that in the objection itself so that the requesting party could have had an opportunity to perhaps revise it, you know, instead of, as they say, throwing a rock and hiding your hand. So yeah, that's a quick way to get under the judge's skin by just throwing in boilerplate. I usually, as I'm reviewing a motion to compel, I usually just go through and just like strike out the boilerplate so I can see just what is the real answer here. Also, when you have the boilerplate, but my answer is going to be, I mean, again, that's silly too, because, you know, I think people sometimes think, well, I have to put the boilerplate in there because I've got to protect myself. Well, that's not protecting yourself. You haven't protected yourself against anything by having the boilerplate there. So just break out of some of those bad habits. And confession, I did boilerplate back in the day. But I've confessed and done penance for it. So just encouraging you all to go forth and sin no more as well.
I couldn't agree more with Judge Wyrick and Judge Claxton that boilerplate of any kind is your worst enemy. Don't send out the maximum number of interrogatories that are the broadest possible scope, asking for the kitchen sink and the faucet, just because you can and because that's the form that you have in your law firm's discovery forms. It goes back to what Judge Wyrick said about what do you really need to prove the elements of your claim or the elements of your defense. And that's what you need to ask for, not just using the boilerplate requests because that's the form you got from some word processing folder on your firm's system. And I echo everything they've said about boilerplate objections, and I very much handle those like Judge Claxton, that I ignore them and direct the lawyer to all of the cases that say those are meaningless. Really, discovery is not a game of give what you get. And I get very frustrated when I see that, whether it is in attitude that because the other lawyer acted unprofessionally or snarkily, if that's a word, I have to give that back to them. But it's also what you're giving in terms of substantive discovery, because I very often and really unfortunately see that the responding party in the dispute says, well, the other side only gave us about 5 pages of documents, so we gave them 6 pages. So we're acting just like they are. It's not, it's as Judge Wyrick says, that's not going to carry the day. What's going to carry the day is I have provided 100 pages of relevant documents, done a diligent search. That's all that we have, and described for me what was done. And if you want to throw in a footnote, although it's not particularly helpful or instructive what the other side did, I suppose that's the least offensive way of handling. But it really doesn't matter to me how the other side has treated you or what the other side has produced. It really is, what are you doing? And that's going to always carry more weight with me than trying to give what you got and use that as some excuse for not having acted cooperatively or professionally or civilly. And I actually put in my case management orders an admonition that I expect lawyers to cooperate and their clients to cooperate in all aspects of fulfilling discovery obligations and to act courteously and professionally and civilly in resolving disputes, and remind them that if they don't, they are likely to face the prospect of sanctions. So a big echo of everything that Judge Claxton and Judge Wyrick said.
Well, that is a great segue into our next line of questioning, if you will, for Judge Claxton. And it has to do with attorneys and dealing with opposing counsel who are being particularly disagreeable, almost to the point of abusive and lacking civility, to the point of obstruction during depositions. It seems like right now, and again, this is another byproduct, it seems like, of COVID, where we're dealing with a lot more counsel that are pro hac vitaed in on cases. They're from all over the country. And normally in the labor and employment section in particular, we have that natural sort of accountability, because we know that we're going to deal with each other and we're going to see each other over and over. And it just doesn't necessarily behoove us to be completely terrible in a case, because there's a high likelihood we're going to see our friends on the other side of the bar again. And so we need to work together. But, I know that I've seen a lot more out of state, out of town pro hac vitae counsel, and I don't want to bash them all together. But Judge Claxton, we have seen that. And what do you recommend as far as how do we handle this, and when, and Judge Wyrick touched on this a moment ago as well, and like, how much background information do you need to know? Do you want to see the transcripts where someone objected to every single question in a deposition? Do you want to see the emails, or or like Judge Wyrick said, where we've had to resort to formal correspondence? How much do you want to know in the context of what brought it to your desk?
Right. So, great question. Before I get to it, though, I want to give a pat on the back to my employment law practitioners in the Western District of Tennessee, because fortunately, I mean, as you said, and coming from employment as my niche, you do see a lot of people over and over again, and you tend not to create those situations where you're going to have a lot of animosity, because you're going to see that person again. But generally speaking, I shake my head when I see the attachments with the emails, because I know what's coming, and I know it's like, here we go. I think it shouldn't get to that point where, because if you've got that kind of extensive timeline where you're doing, now we've got the email back and forth, and now we've got the formal letter where we've set out you probably got 2 months that's gone by at this point. And that's too long. Let's put this in context. In our district, the standard discovery window is 6 to 8 months. Okay, so you don't have 3 months to waste going back and forth over a production, over response, doing emails and so forth, when let's try and head this off early, either by saying, calling Chambers and saying, Your Honor, can we have a conversation with you about this before it has to get to the point of a motion. I think people, again, are stuck in, what is it that I've always done, and therefore not thinking outside the box of other more constructive ways to resolve a matter. With regard to out-of-town counsel, you know, locally we were talking about whether there should be a change to our local rules to once again require local counsel be on a case where lead counsel is from out of town. And we kind of go back and forth on that one because you don't want it to become a local attorney's employment act, where we're padding somebody's pockets, we're making it more expensive for the clients. We're not looking to do that. But by the same token, I've had cases where having that local person meant the difference in a case. A few years back, the worst one I can remember was counsel from a state I won't mention, and I mean he was just the worst. Wasn't even from up north. That's the part that scared me. Is like, my goodness, we could actually have somebody who was even worse than this guy. But his local counsel wound up having to take the case over. The client found out how poorly this guy had acted in discovery, and in the snarky letters and emails that he was sending. And you just kind of wonder, man, I don't know what it's like in your town, but that's just not how we operate down here. And it doesn't advance things for the case. Keep your eye on the ball. What is it that we're trying to do ultimately in the case? We're trying to come to a resolution of the question of the dispute that's before us. And, being, snippy with the other side, or, getting chippy, doesn't advance your case. It's not, at the end of the day, that's not going to help you get anything. It sure doesn't make either side look good in front of the court. It's time wasted on the client's behalf. You're busy getting your shots in, that extra 1/10 of an hour that you're going to spend, writing the snippy email to opposing counsel, you're billing that to your client. You don't have to do that. It's not worth it. So push back from the desk sometimes. Think about what you're doing. I remember, early, in my first stop in my career in the city attorney's office, I was responding to a request that I'd gotten from opposing counsel, and I was going to give it right back to him the way I got it. And I typed the letter up and took it to my supervisor and said, "Hey man, what do you think about this?" And he says, "Looks great." Now take it back to your office, put it in your bottom desk drawer, and start all over again, because it's not going out on the city's letterhead like that. And that's what we have to think about sometimes. Is not just what this says about us as a practitioner, but what it says about us, what it says about our clients. I have to think about that. There are times when litigants have frustrated me, and I've had to really kind of take my time before I put that into an order. I can't just let all my venom go, because parties have frustrated me over the way they've handled discovery, and so we definitely just have to keep all those things in mind. It's better to, again, look at what the time window is. If you have someone that you're dealing with that's contentious on the other side, just really kind of shorten that window and get the court involved. Don't wait. Had a case this week where the parties, the case was filed in February, discovery started in April. The motion to compel, because the April discovery hadn't been responded to, was filed in August, or no, it was filed in July. The order to compel was in mid-August, and the second motion to compel, because they hadn't responded, was in October when they have a discovery bar date in November. So they've wasted their entire discovery period waiting for these to do this when they could have gotten on the phone early. It turns out the reason why they weren't getting quality responses, plaintiff's been in jail since March. So, you know, I mean, they could have gotten on the phone and maybe figured out why the client wasn't being responsive a bit earlier than that to figure out what they wanted to do with the case rather than, you know, wasting all this time. So we have to be attentive to your cases. Don't just let them sit and drift. The more uncooperative opposing counsel is, probably the sooner you start with the formal request rather than just relying on email. Perhaps after a phone call and a confirmation email or a confirmation letter, this will confirm that we agreed or this will confirm that we discussed. And don't be the disagreeable person on the other side of the phone.
Okay.
Yeah, I would,
Judge Holmes?
well, I was just going to say that in response to everything that Judge Claxton has said, which again, not surprisingly, I agree with. I always take my lead from Charmaine Claxton. She's the best. Is that just keep in mind that clients come and go, short-term opposing counsel, for the most part, come and go, the ones that you're having the most difficulty with, and you have to practice where you are for the rest of your career. So what you don't want to do is let a client's silliness or uncooperativeness or their ideas of what litigation ought to be, that it needs to be some kind of combat. And the same for those out-of-town opposing lawyers. Don't let their lead suck you in and follow them, because that's not the kind of reputation that you want to have. And once they're gone, you're the lawyer that still has to appear in front of those judges. And once your reputation is gone, it's a very hard, if not impossible, thing to get back. So always be thinking about that. Also, as Judge Wyrick and Judge Claxton both said, be thinking about what you need in the case and taking a breath every once in a while and moving to the place that your better self wants you to be, and not the self that gives into the temptation to, because you got treated that way, I'm going to treat somebody else that way, or I'm going to let my client send me down a path that I wouldn't otherwise ordinarily go. And sort of a corollary to that, I think, when back talking about emails and correspondence and when those get provided to the court, everything that both of my colleagues said about be careful what you say in those. But I would add to that, don't try to tell me what the email says or the letter says. I can read, and I think we're all pretty good at recognizing undertones and reading between the lines. And it's just going to be worse for you if there's already this set of inflammatory emails or correspondence back and forth. If you just add to that by saying, well, here's what the other side said in their email, when that might not really be what they said, that may be the way you perceived it. But when I look at it, I may say, well, that's not really what they said. And I think that there's some bit of too much of feeding into your client's emotions about the case when you got this. So give me that information, that correspondence, but don't try to give me your spin on it, because it may not be the same way that I would perceive it. And that may be the difference between me coming up with a resolution or not. So those were my thoughts about everything that Judge Claxton just said and earlier comments from Judge Wyrick.
Well, and Heather, if I could, I also will amen Judge Claxton. And this is just, again, it's so nice to hear what my colleagues are doing across the state and pick up some tips. One of the things that we haven't talked about, if I could for just a moment, is we've talked about written discovery. And I heard you throw out something earlier about, do you want to see a deposition transcript? when a deposition's gone off the rail. And I just wanted to mention something briefly, and I am interested in hearing how my colleagues handle this. I actually will get on the phone with attorneys during a deposition if an issue comes up. I would rather address it then, assuming I'm available. I can't promise I'll be available every single time. I have been so far, but there may be times when I'm not. But I would rather get on the phone with counsel and lay an issue down so that the deposition can continue, as opposed to somebody storming out and saying, well, we'll just take this in front of the judge. So I would encourage counsel to get on the phone. With that said, I'll say two things. One is, if you're going that route, make sure that it's something you really feel like is that important that you want to put it in front of the judge. You really want to let the judge know that you all can't work out whatever the issue is. But the other thing I've found, which encourages my practice of being willing to get on the phone, is nobody wants to get on the phone once I say I'm available. Suddenly, magically, the issues seem to work themselves out. So with that said, I did want to let attorneys know that I am willing to do that. But again, my colleagues may have a great take on why they don't do that. So I'm interested in hearing what they have to say too, but I did want to throw that out.
No, I'm happy to take that call too. I haven't had many, but I'll take those calls. I agree with Judge Wyrick. It's almost like when I would tell my kids, I'm going to call your dad. And then all of a sudden, you know, whatever it was they were griping about goes away.
I also will take those calls and have had more of them than I thought I might. Some of which resolve exactly the way that Judge Wyrick and Judge Claxton have described, that when my courtroom deputy gives a time or says, yes, I'm going to get her right now, well, give us a few minutes, and then they do work it out. But some of which I've had to get on the line and work out. If I'm available, so that's always the first condition. And the second is that most times the issues are resolvable right then. They're simple enough. But I have had at least one case where the issue was so complicated that I said, make the objection on the record, reserve that, and then I'm going to let you all come back and we're going to talk about it some more, and I'm going to let you elaborate, because I'm just not prepared to deal with that complex an issue sort of on the fly. So, but I am available, and I think it can be very helpful for it to be known that if one side says, well, I'm going to call the judge, then that's a very real likelihood. And it is, as Judge Wyrick says, amazing, and Judge Claxton, amazing how that can motivate people to resolve the issue on their own.
Well, thank you all. I think that we are running out of time here, and I believe that we've had a really fulsome discussion. Hopefully all of the participants on the webinar today have gotten a lot that they can take away from it. I know that I have. It sounds like you all have shared a lot of information among yourselves, which is great to hear. So the purpose of the program has been served, but thank you all so much for appearing this morning and sharing your thoughts about this really important issue, because all of us in the labor and employment section deal with this every single day. So really helpful information. Thank y'all so much.